Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 100. I think we ought to mark that with a drum roll or a fanfare of trumpets or something. No? Oh well, anyway. I have to say, when I started off this podcast series, I never thought we'd get to 100, but I'm really delighted we're still going strong. I've recorded a special separate podcast with just some thoughts and observations, things I've learnt from doing a podcast series. Do have a listen. And it's partly, and quite genuinely, intended to be encouragement to anyone else out there who's thinking of doing a podcast series, so there's some sort of semi-serious stuff in there too. It's accompanied, or it will be accompanied when we release it next week, by a not entirely sensible video, which certainly doesn't let any light in on the magic. Well, to business. The three cases we have today are a case on indirect sex discrimination and work rostering, a further case on the role of HR in internal disciplinary and grievance hearings, and an issue on reasonable adjustments for a disabled employee. And finally, and I promise no more than 2 minutes, summer festival highlights. You know you weren't going to escape without me banging on about things I've seen over the summer. As usual, please don't forget you can access the podcast via iTunes, it's on the Mayor Brown internet or YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, and that's also, of course, where we post out the links to all the cases discussed. So, first case, XC Trains Limited and CD and another. This is an EAT decision concerned with whether the claimant had suffered indirect sex discrimination because of the way her work rosters operated. It's a very useful case because it seems to emphasise the need for tribunals to focus on the justifications put forward by the employer for the alleged indirect discrimination, rather than the laudable aims which the tribunal had and which it then used to judge the employer. The claimant worked for the first respondent as a train driver. There were 559 train drivers working for the first respondent, of whom 17 were women. She was based at the Newcastle train station, where there were 21 drivers, of whom 4 were women. The company operated what sounds to me like a very complicated shift system. Basically, there were 25 different weekly shifts covering the range of the operating hours for trains, and only 2 of those were family-friendly hours, i.e. beginning and ending between 8 a.m. and 6 p.m. The claimant was rostered, like any other driver, to work a 35-hour week over 6 days. She had 3 children, and she applied on various occasions for a formal flexible working application to be allowed to change her arrangements permanently. The flexible working requests were all rejected, although some leeway was granted to her, it appears, on an interim basis. These are so-called accommodations. However, it seems that the other drivers were becoming increasingly frustrated about working more antisocial shifts as a result of this driver working more social shifts, if I can put it in those terms, and ultimately it proved impossible to resolve matters completely by agreement. The respondent was expressing concerns to the claimant about its ability to meet customer needs alongside the workforce requirements. Well, an accommodation of sorts was reached, but it didn't meet the claimant's full desires for flexible working, and so she brought proceedings claiming she'd been discriminated against on the grounds of her sex because there'd been a provision, criterion or practice applied to her. So the Equality Act 2010, Section 19, provides that if the employer applies a provision, criterion or practice to her, and if it done that and it was discriminatory by reason of her gender, and it put her at a disadvantage, and the employer could not show it to be a proportionate means of achieving a legitimate aim, then this would be unlawful discrimination. Turn it on its head, if it could show it was a proportionate means of achieving a legitimate aim, then that would be operate as a defence. I think it's fair to say, reading what the EAT has to say about the Employment Tribunal decision, that the Employment Tribunal appears to have had strong views about the male-dominated environment in which the claimant was working. The company put forward as its justifications the need to comply with the obligations it had contractually entered into as a train service provider, and as a result, this required its drivers to work antisocial hours, for which they all received high salaries. However, the Employment Tribunal commented repeatedly on the fact there were so few women in the workforce and wondered why this was so. It made clear its view that the employer needed to challenge the status quo and the shift system. Otherwise, quote, one of the last male work bastions will be perpetuated, unquote. And I think you can see if you're on acting for the employer and the tribunal starts talking about one of the last male work bastions, you know this isn't going terribly well. Anyway, the EAT took a rather more measured view of the situation. It pointed out the tribunal had been entitled to find that there had been a provision, criterion or practice applied, and that the requirement to work at least 50% of their roster and a number of Saturdays put women at a particular disadvantage because of their caring responsibilities. However, the tribunal felt that the tribunal's consideration of the objective justification of the PCP had fallen short. There had been no attempt to balance the discriminatory effect of the PCP against legitimate aims of the employer looking to run a train service fulfilling its contractual obligations under the franchise. It also was concerned about the rights and needs of its wider workforce. The claimant wished to be employed and paid as a full-time driver, but a change in her hours would mean the other drivers would have to work more antisocial hours, including more weekend working. The creative thinking to resolve this problem, which the Employment Tribunal had suggested, either involved additional cost or would have an adverse impact on the other drivers. Therefore, the Employment Tribunal had failed to weigh the first respondent's legitimate aims and instead focused on its own laudable aim for a company to have a gender-balanced workforce. The EAT said it was an error of law for the Tribunal to come up with ways of removing the discriminatory effect of the PCP without considering the effect on the other drivers. Accordingly, the case was sent back to a different Employment Tribunal for the justification question to be reconsidered. Well, I think this is really quite a helpful case for employers. Clearly, the employer here ran into an employment tribunal that's very keen to open up the workforce to a greater number of women, and which speculated that the working patterns adopted by the employer might well have put women off. However, as the EAT pointed out, it was for the employer to identify its justifications, and for those reasons then to be weighed against a discriminatory effect. Given that the workforce apparently been firmly against the extent of the changes sought by the claimant, and there were no other obvious options, it'll be interesting to see how an employment tribunal weighs in the balance requiring non-parents, or indeed male parents indeed, to work more antisocial hours against the disadvantage of disadvantaging this claimant. It sounds a bit like a judgment of Solomon to me. And I remember an early case on, I think, the disability discrimination legislation, where the judge, giving the decision, commented that anyone who thought the questions raised by this area of discrimination were easy clearly had not reflected on this area of discrimination to any great extent. Here, I suspect that people could take strong views on either side of the equation, and the real-world implications of this sort of case are tricky. Clearly, this particular claimant had a legitimate expectation some flexibility should be shown to her by virtue of the fact that she is a woman who wanted to look after her children in her time off work, and women disproportionately are still the primary carers. How is that to be evaluated if you're running a business against the desires of other drivers, men and women, with what they wish to do in their private time? How would you as an employer try and differentiate between someone who's engaged in elder care or valid charitable work as against looking after children? And to take a hypothetical example, and I have to emphasise it's not part of this case, indeed the facts seem to be completely counter to it. What would happen if you were running a business and this sort of situation arose, but the husband of the woman who was seeking the childcare arrangements could easily look after the kids but was choosing not to? How do you weigh that against a male driver, let's use this example, who says that their childcare arrangements will be adversely impacted if they're working more antisocial hours? Whilst the law might put victims of discrimination in a different category to all the other examples I've just given, if you're trying to run a business, compromise and flexibility seems to be the order of the day. I also suspect the tribunal is not really going to want to be regularly involved in evaluating work roster schemes to see whether they have gone as far as is necessary in showing flexibility for victims of discrimination. That seem to be business decisions which tribunals often tend to shy away from. Ironically here, the fact the employer seems to have had some sort of consultative forum which enabled drivers to express their views on alterations to the standard shift working and accommodations meant there was very clear evidence of the driver's view of the situation of what they were being asked to accept. As we'll see in a case coming up later on in this podcast, an employer who said it had similar sorts of concerns about the reactions of a workforce but didn't have the evidence came rather unstuck in front of the tribunal. So, anyway, it'll be interesting to see if this case, on the justification, which has been sent back to the tribunal, it'll be interesting to see if that case makes the case reports and how that one ends. So, next case. Dronsfield and University of Reading, another EAT case, and this one's dealing with an unfair dismissal claim by an associate professor. There were a number of points in the case, but I'm just going to focus on one part of it because that's the point of general application. Case concerned the claimant's behaviour with one of his students. Under the guidance provided to staff at this university, if there is any, quote, non-academic relationship, unquote, with a student, then the teacher has to withdraw from teaching the student, and it's also necessary for the teacher to inform the university of the existence of that non-academic relationship. Claimant did develop a non-academic relationship with a female student, albeit I think relatively briefly, but he didn't report it. This came out, he was dismissed, and an employment tribunal upheld the fairness of the dismissal. As I say, there were a number of grounds on which the matter went up to the AT, but the one I want to focus on is related to the production of the report which led to his dismissal. The investigation report was produced by two people, a Professor Green and a Ms. Ralston. She was from HR. The final report, which was shown to the claimant, of course, and the disciplinary panel, acknowledged that the claimant had been frank and honest with them, and so they accepted that what he told them was true, without them going through any further investigation. They also accepted that there was no predatory intent when he entered the relationship. However, the report took a very serious view of the failure to report the relationship and said that there was evidence that he was acting in breach of his duty of care and responsibilities towards students. The report went to the disciplinary panel and he was dismissed. However, during the tribunal case, it became apparent that earlier versions of the Green-Ralston report had varied significantly from the one that was produced finally and handed over. Various statements in the early drafts of the report, which were favourable to the claimant, were simply removed from the report altogether. The Employment Tribunal accepted Professor Green's oral evidence that he signed off the report and it represented his genuine personal views and findings. Similarly, a written statement from Ms. Ralston, who I don't think gave evidence, her written statement appears to have made the same point. The tribunal found there was nothing improper or biased in the advice given to Professor Green, and the tribunal accepted his evidence. He'd signed it off in good faith, and it accurately represented his conclusions. So, the question for the AT was whether Professor Green's statement, which was accepted by the tribunal, as I say, that he signed off the report in good faith because it accurately represented his conclusions, was an answer to the claimant's concerns about the comments left out of the draft. The claimant argued it wasn't a question of establishing subjective integrity of the person who did the report. It was a case of looking at the report's objective fairness for the purpose of testing whether a dismissal was unfair. The claimant's argument was that the failure to keep in the favourable comments in the earlier reports meant that those making the decision on the disciplinary process did not have the full range of information available to them. The AT agreed with the claimant. They said there's nothing to suggest that Professor Green had changed his mind on the points which had been omitted. The Employment Tribunal had simply not asked itself whether he changed his mind or whether those favourable comments had simply been, in effect, withheld from the final report. If he still held those significant opinions, the question for the Employment Tribunal would be whether it was reasonable for Mr. Dronsfield to be dismissed in circumstances where important conclusions which should have been in the report and which were favourable to Mr. Dronsfield about the charges in question were left out. Of course, we've been here recently with the Ramphal and Department of Transport case. The EAT in the Dronsfield case said that it supported the approach adopted in the Ramphal case by the EAT. As we indicated at the time, there was, we felt, a degree of internal inconsistency in Ramphal itself, and a lot of our clients were certainly very surprised by the attempts to limit the role of HR in the rather formulaic way that Ramphal envisaged. However, here we have another case of the EAT similarly cutting back on the role of HR and voicing its support for the Ramphal approach. The complication here, the addition I should say, was that the report was jointly produced by HR and Professor Green, and it was signed off on that basis. In Ramphal, HR's influence was not as overt. I want to make the point, though, that other than supporting Ramphal, which is, in my personal opinion, a tad unfortunate, the case is maybe less significant than you might think. First, the judge did comment on the role of HR as joint producers of the report, and the judge said it wasn't normal practice to have a joint sign-off. However, the judge went on to say, "I'm conscious I've not seen the letter of appointment which set up the investigation," unquote. In other words, it seems to be implicit in that if the letter of investigation set up that there was going to be a joint report, then this judge was not saying that was unacceptable. Now, we'd recommended that if you wanted to have HR fully involved in all aspects of the production of the report after Ramphal, but being compliant with Ramphal, one way was to have HR identified as the joint decision makers. A couple of the summaries of this particular case, the Dronsfield case, seem to indicate that was no longer acceptable. However, I think when you see the full decision, the judge's comments seen in context certainly does not determine the point and seems to imply that investigation stage is expressly set up as having line management and HR involved jointly. There's no suggestion that would be objectionable. Secondly, the point which caused the downfall of the employer in this case was that nobody seemed to ask Professor Green during the original Employment Tribunal hearing whether he still agreed with his earlier drafts or whether he changed his mind. Now, that's obviously quite a surprising finding, but okay. The EAT does not say it's inappropriate to rewrite reports or go through various drafts of the report. The concern is that if he held those opinions, and they were favourable to the claimant, but this was not put into his report, then his report would have been a misleading one. That's a rather narrower point, and it's an eminently sensible point for the EAT to make, of course. But if Professor Green says he changed his mind, and they no longer held those views, and the tribunal in the revised hearings continues to accept now that he is still telling the truth, i.e. he genuinely changed his mind, so those comments were no longer relevant, I'm not sure where this argument will lead the claimant. Of course, the case continues, and we only have the EAT report to go on, so there could easily be other factors which didn't weave their way into the EAT hearing. So, third and final case, G4S Cash Solutions UK Limited and Powell. This, to be honest, is a rather odd and frankly quite unhelpful case. Concerns an individual who is disabled and as a result was unable to do the job he was originally employed to do at G4S. He was transferred to another job and for a period remained at his old rate of pay, which was higher than the rate for the job he went to. However, the employer then tried to impose the appropriate, I use that in inverted commas, lower rate of pay for the revised job, and when the claimant refused to accept this, he was dismissed. There were two main parts to this case. First, there was an issue as to what had happened when the claimant had moved to the new role. It was accepted by the employer that the manager for the claimant had allowed the claimant to believe that this arrangement, i.e. the continuation of pay, was long-term, but the employer disputed whether or not there had actually been a variation in the contract of employment, or whether this was simply a reasonable adjustment, which it could undo unilaterally at any time. The Employment Tribunal appeared to accept an argument that an employer could impose a reasonable adjustment on an employee unilaterally, and so that wasn't a matter of contractual variation. And it seems to follow from that, if it wasn't contractual variation when it was set up, it could be withdrawn unilaterally by the employer at the right point in time. The EAT was having none of this argument. The employee was entitled to refuse a variation in contract, whether or not it was in pursuit of a reasonable adjustment made because the employee was disabled. The real issue in this case, therefore, is the suggestion by the Employment Tribunal that it was a reasonable adjustment if the individual was moved to a new role for which the appropriate salary was lower for the employee to continue to receive, on an ongoing basis, his old higher salary. This, I think, is the worrying part. The Employment Tribunal recorded that the respondent did not want to pay the higher rate because it caused discontent amongst other employees if they knew that Mr. Powell was given special treatment. The Employment Tribunal pointed out that nobody else was in the same circumstance, or if they were, certainly no evidence had been forthcoming. And if Mr. Powell had been on the old higher rate for a year and nobody had complained, that probably indicated this wasn't such a major issue. At the EAT, the employer argued strongly against this decision and argued that maintaining pay at the old rate was not an appropriate adjustment for the tribunal to require it to make. The EAT accepted that the claimant was faced with a choice of either being dismissed or taking the job at a low rate of pay. This would not have happened if he'd been a non-disabled employee in the same situation. They took the view that it was a reasonable adjustment to require an employer to carry on paying an employee at the old rate of pay, even when the new job carried a lower rate of pay. Pay protection was a step that should be considered. Cases such as O'Hanlon, where it was said that it would be a rare and exceptional case that requires an employer to continue discretionary sick pay as a reasonable adjustment, were not directly in point. Not surprisingly, the employers here said that if it was an exceptional case to continue sick pay beyond the point at which contractual sick pay ended, then it should be similarly exceptional to have to continue the old rate of pay, and there was nothing exceptional here. The EAT brushed this aside. Indeed, they turned it on its head. They said that if enhanced sick pay could be a reasonable adjustment, albeit in exceptional circumstances, there was no reason to think that ordinary pay protection for work was completely outside the legislation. They said that the objective is to keep employees in work, and the EA could see no reason why this would not include pay protection. Well, That, I think, is the problem in the case. I think it's extremely difficult to draw a distinction between the EAT's pronouncement in the earlier O'Hanlon case against having to continue discretionary sick pay, which would keep an employee in employment, if not actively at work, and requiring an employer to pay ongoing pay at an old rate of pay for a lower paid new job. The reasonable adjustment, I think most employers would say, was offering the employee the new role. The new role carries a salary at a particular level. Therefore, the adjustment and the effort to keep the effect of keeping the employee in paid employment have been met. That is the adjustment. But clearly employers are now going to face arguments that moving people on to revised rates of pay when they're moved down into lower paid jobs with their consent, that there's a further reasonable adjustment that says they should keep their old rates of pay. This is clearly very, very significant, because I think invariably in cases where we've been advising so far, it has been the common assumption of both parties that employees, if they were moving to a new job, would get the rate of pay for the new job. I don't think I've ever had an employee or employee representative say that we ought to keep them at their old rate of pay. Sometimes, as a matter of discretion, they've been kept at their old rate of pay for the length of the notional notice period, because that's often quite a sensible compromise. But beyond that, I don't think I've even had the argument come up. So clearly there are going to be cases on this, but it's clearly as well, if you are advising employers or employees on reasonable adjustments, this case is important. Finally, I promised to do a really, really quick update on the various fantastic things I saw during the festival season. I ended up going to 4 different festivals, and also to the Edinburgh Festival. So I had a good summer, inevitably. But in no particular order, if you get a chance to see any of the following, grab them with both hands. So Christina and the Queens, who I think I mentioned I saw at Latitude, who were fantastic. Shake, which, and roll with me here, Shakespeare, Twelfth Night, done in French, unbelievably cool. Saw it at the Edinburgh Festival. It was utterly magnificent and brilliant in ways I probably don't have time in this podcast to go into. Robert Plant playing Whole Lotta Love at Wilderness. That was a seminal moment, and the audience went absolutely bonkers for it. Great fun. And from WOMAD, the Martin Bennett Grit Orchestra. Incredibly moving to hear music played live for Martin Bennett, who died more than 10 years ago now. But it was amazing how many in the audience clearly found it quite emotional hearing this music played live for the first time in many, many years. Anyway, there are stories behind all of them, and there's another load of great experiences. So beware bumping into me in the street. I may just bang on for hours and hours about the great things I saw. Anyway, in all seriousness, thank you very much for listening to this podcast. Thank you for those who've been with the podcast from the start. It's much appreciated. And I hope we'll get to do another 100, and who knows, 100 after that. Keep an eye open for the companion podcast, the one-off that we're doing with lessons I've learned whilst doing the podcast and the Not Entirely Sensible video. And otherwise, on to podcast 101. Sounds vaguely threatening, which I think will probably come up towards the end of next week. We're a week out of step for various reasons. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.